Hi, this is Steve Dale, and according to my computer, this is August 27th. We're going to talk about a program. We've actually been doing this with RMS for years and years and years here. For those of you that were watching some of the little pre-session we had, as I like to say, oftentimes our friends from RMS team, their job is to tell us things that we really don't want to hear, but we need to hear here. And this is a really important part of being the trustee of not only the special needs trust, but whenever you have caregivers. So I think this is an incredibly important topic we're going to talk about. For those of you that are not familiar with RMS team, you must have been under a rock here, because as we were talking about earlier, Cheryl, how long has RMS team been around?
About 20 years.
And I know I've worked with them for at least 20 years. So, and once again, they've become a cornerstone when it comes to working with employees and that kind of thing. A little thing about Cheryl here is Cheryl oversees team's client services, human resources, and compliance functions. She joined team in 2014 as the company's HR manager, and also previously served as director of client services for HR. She brings 20 years of experience delivering client-focused solutions and HR experience to companies of all sizes across several industries. She combines her passion for providing impeccable service and account management with her strategic HR thought partnership. Cheryl holds a Bachelor's of Arts degree in communications from San Diego State University. So that's a pretty impressive here, Vitae and all that. So with that, we are going to, please, if you have questions here, please post those here under questions. We're going to try to take questions towards the end here so that Cheryl can get through the main part of this. But once again, this is an incredibly important program. Now, just getting through the portion having to do with accreditation. This program has been approved for 1.5 units of MCLE credit by the State Bar of California by the North Bay Housing Coalition provider number 14598. The North Bay Housing Coalition, by the way, is the nonprofit here that owns the Golden State Pool Trust. So if you wonder why they're in there, that's why. This program has 3 codes that are announced during the program that the viewer will need to record to verify participation in the class. If you wish to receive MCLE credit, please download the credit form once again at the gspt.org website under attorney resources and fill in the proper codes. Now, if you don't have it in front of you, just make sure you write down the codes, okay? Because that's what we got to do to give credit. To be placed on our mailing list for future programs or to receive assistance with credit, you can always email amy@gspt.org. So, Cheryl, welcome aboard. Thanks so much. Always, by the way, we use Team exclusively. Here we at GSPT, and we also use it at the Dale Law Firm as well. So, Cheryl, tell us something a little bit about team and the subject and all that. So.
Yeah, great. Thanks so much, Steve. And hi, everyone. Thanks so much for having me today. So as Steve mentioned, I am with Team Risk Management Strategies. We specialize in providing outsourced payroll and HR services for fiduciaries and trustees, and pretty exclusively when it comes to household workers, domestic staff. So anything from, it could be caregivers and nannies, could also be other domestic worker type roles, such as housekeepers or property managers, maintenance workers, really kind of runs the gamut. Given obviously our unique area of focus, and in my personal experience while at Team working with clients over the past 10 years or so, we've certainly navigated our fair share of I will say complex issues, learning moments, certainly sprinkled in there as well. And really what we are going to be focusing on today is just ways to ensure compliance. And I'll share some just best practices just from my time in the field as an HR professional on really how to manage employees in a way that is going to set everything up for success and make sure that any risk or liability is really minimized, especially any liability potentially to the trust, to your clients, et cetera. So this deck, I believe, will be shared. I think there was a link shared in the chat. So hopefully everyone has access to it. This will alleviate the need to take copious notes, except for those MCLE codes that Steve mentioned. You do want to jot those down, but everything else will be shared. As I dive in, I just want to kind of frame our discussion for today. There are countless ways, really. There's a lot of different ways to handle what I would call like household employment or caregiver employment. We're going to really tailor a lot of the language used in today's presentation to caregivers. My understanding is this is predominantly the role that most clients are potentially looking to fill, are in that caregiver, companion, maybe nanny space. And so just to further frame really the sliver that we're going to be focusing on today, when you think about ways to handle this type of employment, there are two sides. There is public funding, so Medicaid type programs that many clients or beneficiaries, trust beneficiaries may be eligible for. There could be programs through the VA, other regional centers, and this would be one avenue and one means to pay caregivers. The other side is on the private pay or trust paid side of it. And this can be kind of handled in two different ways. Really, is this something that's going to be outsourced? Perhaps a home health agency is engaged and they're going to assess the needs of the clients. They're going to then take someone from their team, place them, within the home and just sort of help manage the needs that way. If the family is maybe looking to do things more on their own and they want to hire their own people and they want to manage things day to day and they're kind of managing things, you could utilize a service like an employer of record service, or sometimes the trust or conservatorship opts to pay directly. And that's really the sliver we're going to be focusing on today. All of the guidance that I'm sharing is really when there's a need to kind of do things on your own and set things up from start to finish. And so that could be, paying people directly, still a W-2 employee, but certainly things you want to avoid is like cash or misclassification of a worker as an independent contractor, which we'll get into here momentarily. But when we're talking about today's discussion, this is really kind of where we're framing it, is on the private pay side, trust paid employment situations. And the reason that this really matters is because actually like cutting the check and making a payment to someone in exchange for services, that's really the easy thing. But when you follow the money and you see where is that payment actually coming from, it really answers the question of who is sitting in that employer seat. And so if there are direct payments being made to workers out of a trust, then by default, an employment relationship has been created, even if that wasn't intentional or that's not the intent of the relationship between parties of trustee or worker. And this does include family members as well. If there's family members receiving stipends in exchange for being a caregiver for their loved one, they essentially have some sort of employment arrangement with the trust. And it's important to know that exists, because really there really isn't anything, there's no such thing as just payroll, right? There are definitely strings attached. And so not only is it important to make sure that the payments are being handled compliantly, the right minimum wage and overtime is being factored in, and the right taxes are being taken out, and all of those logistical items that go along with running payroll. but there's a lot more responsibility that then falls on whoever is sitting in that seat as the quote unquote employer. And we know that this is often on top of a lot of the other duties that a fiduciary or a trustee is managing in that capacity. I'm going to share a quick story just to illustrate this further. As you may or may not know, we work with hundreds of fiduciaries, corporate trustees, banks across the country. And this is a story that actually came from one of our clients pre-team, but we were working with a specific trust officer in an S&T division at a bank. And this particular trustee or trust officer, excuse me, had set up the account to pay the mother of a trust beneficiary and a third-party respite caregiver, just so the mom had a break, over the weekends and a couple other days throughout the month. She set up an outsourced payroll service to handle the wage payments. So like just a traditional kind of payroll service to do all of that. And they handled the tax filings and they issued W-2s at the end of the year, and they handled all the time cards, which was great. The account was pretty quiet. Everyone was kind of getting along. There were no red flags. Everything went really smoothly. And then there was a really unfortunate situation where the respite caregiver was working one weekend, took a tumble down the stairs, resulted in some pretty serious injuries, had to have some surgeries because of some facial fractures even. And it was really not until that time that they realized there wasn't a work comp policy in place. So while the payroll pieces were all set up, it wasn't truly set up as an employing entity, didn't fall back on homeowners in that situation. And just a really unfortunate situation all the way around. Thankfully, the caregiver was okay and recovered pretty fully, but it was not at no cost. And all of that cost and burden really fell on the trust and the trust assets at that time. This wasn't a massive trust, but it was a trust nonetheless, and set up to provide money for a trust beneficiary. But because of this injury, 50% of the assets at the time were essentially depleted just from one incident of having to pay for lost time for this worker, for penalties of not having work comp insurance, for the medical needs of this individual. This is also on top of just the amount of time that really detracted from what that trust officer was working on to be able to just focus on also navigating and managing what turned out to be a work comp claim.
Cheryl, I think for a lot of the folks that are watching this, I know for myself, both as a fiduciary, as an attorney, you get a lot of this back from folks about, well, is this optional or that kind of thing? And I think for a lot of folks, you need to get the religion, because we all have stories. I think I was telling you that I had one where I had a client that ignored my counsel and ended up paying a $60,000 fine out of his own pocket, and he got out easy. And so this is not an optional thing. And you may be getting into this, but with the kind of people we take care of, I'm a former gero psych nurse. The incidence of injury out there is really high, and believe me, a claim for somebody who hasn't been paid their comp and that kind of thing is a very unpleasant experience. So
yeah, absolutely. And it's like most insurance, you get it because you hope to never need it, but when you do need it, you're really grateful that it's there.
Okay, and then we get to our first code.
We went right through that.
Sorry. Okay, anyway, our code number 1 is 8923. That's 8923. And once again, if you don't have the MCLE form, you can find it at the GSPT website under attorney resources. Okay, well, let's plow ahead.
Okay, wonderful. Right. So just to sum up that story again, this was a very well-intentioned trust officer, wanted to make sure she got folks on the books, was getting them paid correctly, the right taxes coming out, And those are all really important on its own as well. Caregivers, companions, those are always going to be employees. And I will say the riskiest employee is the one you don't know you have, because it isn't until something goes wrong that all of a sudden things start to snowball, things can get pretty costly. And as highlighted in that example, employment liability is one of the things that can pierce the veil of a trust. And so it opens the trust, the trustee, anyone operating in that fiduciary capacity, sometimes the family, to additional liability and burden. So, and on top of that, and just getting those nuts and bolts, just the time and the energy to stay on top of changing regulations and changing laws. And I know that aspect is not lost on this group as well. You see this all the time with different Medicaid laws that are passing, and it's no different in the employment law landscape. Following HR best practices, just how to avoid the conflicts, how to diffuse conflicts when they come up so that they don't snowball, and then having all the right nuts and bolts around it, the right insurance policies, the right procedures in general. And this is all to essentially just minimize financial risk, reputational risk, legal, issues from occurring. So with that, not to focus on the doom and gloom, but really I think that's a good segue. And just the idea is that it hopefully paints the picture of like, hey, this stuff does happen. It was shared with us by a now client about a time, in their past, which we appreciate. What we're going to focus on for the rest of our time together today is I will be going through essentially 5 core areas of the employment life cycle and sharing some tips, some best practices. I'll weave in a couple more stories as well, just from our quote unquote learning moments that I mentioned earlier on. And we'll really kind of cover things and ways to set this up from success from the beginning, throughout the middle, and then at the end. So with that, I will go ahead and dive in to the first tip or focus area, which is to classify employees properly. So you want to know that you have an employee to begin with, and that you're not just by default saying everybody is an independent contractor. There are various tests used at the state and federal level by different agencies that will help determine the legal or make the legal determination about whether someone is an employee or an independent contractor. The Department of Labor has its own test. California uses a slightly different test, which is more stringent than the Department of Labor's test. And they all have their list of questions that you can run through, and it's a very technical analysis. Practically speaking, these questions get you a majority of the way there. And if you are answering yes to any of these questions when you look at an arrangement where an employee is being paid, when an individual is being paid, let's say directly by the family or directly by the trust, if you are answering yes to any of these questions, then that provider, that individual is likely a W-2 employee. So they are only working with one family or one client. This is not a situation where they maybe have their own business and they're coming in and providing services that they're advertising for in the market, and then you retain their services, but so do a dozen other clients. I know this is written backwards. If they lack their own professional liability insurance, so if they do not have their own, then they're probably an employee. They're relying on other liability protections out there. And if they're getting regular ongoing disbursements or payments. And so the way that this is often looked at is, where is the one economic dependency? So if there's if that individual has an economic dependency on the client to earn a living, that is usually one of the arguments that would be made. Again, it's not up to them to go out and get a ton of clients. They get a job, they take a job, and for the foreseeable future, they expect to kind of have that job and be paid for it. And the other is the level of control. Who is controlling the schedule? Who is controlling the way the work needs to be done? If this is a situation where you or the client is saying, hey, I'm hiring someone to come in and work from 9 a.m. to 4 p.m. Monday through Thursdays, and on Saturdays from 10 a.m. to 4 p.m. very much the control of who's setting the schedule rests with you, rests with the client. Whereas with an independent contractor, they're sort of telling you when they can slot you in, right? Hey, I'm happy to work on your kitchen or come do your plumbing job, but I can fit you in on this week or this week over here. So they are maintaining some control of the schedule and likely how the work is going to be done as well. Again, if you have anyone working in and around the home, companions, caregivers, other household employees, those are most likely going to be employees, usually ruled that way. What doesn't matter is the individual's preference to be considered an independent contractor. They may come to you begging to be paid under the table and just have a handshake agreement. And they don't want to be on anybody's radar. And all of that is great in the beginning, but it would not hold up if challenged down the road, even if there's a written agreement. You could have the best written agreement in the world that says, I agree, I'm an independent contractor, I want to be an independent contractor. It doesn't matter if it's challenged. And same thing for family member as well. So again, it's just really important to know you have an employee to begin with. Again, I mentioned earlier, the riskiest employee is the one I think the one you don't know you have is what I think is the riskiest employee to have. Moving on to the second component, which is great, you have an employee, let's make sure the full employment relationship is set up compliantly, that there's actually an entity here that exists and it's not just checks being cut, personal checks being cut from an account. It's really critical to set up all the right tax accounts, pay required taxes, set up an unemployment account. This could include in California, that's including things for paid family medical leave programs. Other states have similar programs as well. So a lot of programs that are administered by the state that really you as the employer would never have to really manage or deal with, but there are still responsibilities to get the account set up, to withhold, remit taxes appropriately for these various programs, and making sure that payroll taxes are being withheld and paid. Certainly never paying under the table is, I think, one absolute that I would feel comfortable saying is always want to kind of pay on the books. The other piece of it is insurance. Failure to have insurance, work comp, can result in a hefty fine, even if nobody gets hurt. And it is required in most states, even if you have just one employee. Typically, work-related incidents are excluded from homeowners policy. So it's really important to understand the kind of fine print of those policies. And one homeowner's policy may have something different than a different one. They're all crafted very uniquely. We've seen clients charged north of, we had a client in New York, they were charged north of $100,000 in penalties for not having work comp insurance on a single trust. And those penalties were really steep and pretty painful to absorb. Here in California, not having work comp could be a criminal offense if egregious enough, could result in jail time for the owner or operator of the business. And as Steve mentioned earlier, in-home care is actually a pretty high risk type of profession. You have lots of lifting, lots of aiding, lots of bending over, lots of, bending over around tight corners. These are not hospitals with wide walkways and huge doorways to fit through. You're navigating staircases that aren't optimized to help individuals. Again, lots of hands-on movements, from what I understand. And so, and then just other run-of-the-mill injuries around the home, burns, cuts, jam fingers. We see a lot of jam finger injuries of just trying to push a wheelchair through a door that's a little too narrow and cutting that corner not quite right. We've seen family members and family members get injured as well. And that just because their mom, husband, adult child, it doesn't mean that they're also not performing a physically demanding job. We've seen back injuries from parents. We've seen $90,000 settlements to parents for a single work comp injury. So work comp is probably the most important insurance. However, there are other lines that you may want to consider, whether that's EPLI, general liability, theft, neglect, abuse, anything that will help to protect you or anyone sitting in that employer seat is important to consider as part of getting the overall entity established. All right. So moving right along in our employment life cycle, I'm going to spend a little bit of time talking about hiring best practices. So in many cases, when employees are being paid directly from a trust or by the family directly, it's also because it is the family who is doing, or maybe this is part of the service that you're providing to the family. Someone is doing the hiring, someone is making the selection. And hiring is critical for clients. One, you want to ensure consistency for clients. Ultimately, good hiring decisions mean that trust beneficiaries are getting the services, the care they need, and they can rely on having a good continuity of care. I know there's a lot of talk out there, or I know it's a big pain point right now, just caregiver shortages. And I know lots of families and clients who really struggle with this. And so to make sure that when there is a hiring decision that's made, it's a good hiring decision, the less times you kind of have to rinse and repeat and kind of go through that. And then the other one is just more from a practical standpoint, there is liability in the hiring process as well. So making sure that there are some best practices that are being followed can really help you make sure that liability is minimized. And before we get into more tips, I'm going to pass it over to Steve.
And here we go with our MCLE code number 2, except that was fast. We need to go backwards.
Oh, I did go through it. Wow.
There we go. Okay.
The second time. Thank you.
Write it down that fast. Okay.
No, that's
our
okay.
Second code is 0011. Code number 2 is 0011. And once again, if you need to find the form, you can find it at the gspt.org under attorney resources. Okay, well, we're on a roll here.
Okay, wonderful. Diving into hiring best practices, I'm going to share another story. So we were contacted by this time an existing client, and they were somewhat in a panic and just looking for guidance. Team doesn't do recruiting, we don't do placements, but certainly just knowing our HR expertise, wanted to see if we had any suggestions or ideas for them. But essentially they called panicking because they needed to replace an essential caregiver who had just walked off the job. She had been with the client for all of 2 or 3 weeks. She was hired to provide some caregiving, companion care for a child, for their child who is the trust beneficiary. They also asked her, hey, we will need some general support around the house, just with some general household duties from time to time. Everything seemed to be going well, but in her 2nd or 3rd week of work, she showed up for her shift. They said, hey, we have things with our child taken care of. Could you use today and go down to our basement and clean out the fridge and do a deep clean of the basement fridge? And this was not what she was expecting. She felt like there was too many household duties being thrown her way, and she was feeling a little bit more like a glorified housekeeper. That was sort of the straw for her. And so she grabbed her belongings and said, I don't think this is the right fit for me, and essentially walked off the job. And the learning there was that duties can vary really widely, and where, talking through this a bit with the family and just trying to break down, like, how do we avoid this in the future and what could we do maybe differently? What we really identified is when you say something like general household duties and you're not being specific about the job duties that person should be expected to perform on a day-to-day basis, they're going to likely hear one thing and not the real thing that's being expected. So being clear and actually outlining if this was meant to be 50-60% housekeeping and 40-50% childcare and caregiving services, that needed to be more clearly outlined from the get-go. And so that was kind of a mutual learning that they had on how to avoid the situation. They were left in a pinch, certainly in that moment, but really appreciated that they kind of leaned in to figure out how could we do this differently. So some best practices to ensure good hiring outcomes. One, again, be really clear about the job duties and the expectations of the role so that there are no surprises. Number two is to be clear about ideal candidate qualifications. So sometimes this goes even beyond skills, beyond experience. But what do you need in that instance? This is really going to vary greatly from client to client. But do you have a client that maybe prefers someone who's a little more quiet? Do you need someone who is chatty? Maybe the client just is looking to have conversations all day throughout the day, and you need someone to kind of come in and match that energy. Is this a very active and dynamic family, and you need the caregiver to come in and sort of do their part of it, but then stay in the background and let the family really operate as a family unit to the best that they can and be able to kind of read and understand that nuance? There's a lot of nuance, it's a good word for it. There's a lot of nuance in when you're talking about a household type role and what one client may want or prefer versus another. And so being clear about what the ideal candidate could look like, I think helps set things up for success. Writing out questions in advance. I know it's a little additional lift on whoever is doing the interviewing, but one, it makes sure that you're really going to focus and cover all of the areas that you need to cover to make an informed decision and without getting too off track. And then staying consistent with the questions that are being asked of multiple candidates. That's going to make it easy to rate candidate A to candidate B to candidate C. If you've asked wildly different questions and you're just sitting down and kind of winging it, at the end of it, it's going to be really difficult to pick which one really measured up on the things that were most important to you in that time. So those were some best practices of things to ensure a successful hire. Here are a few tips of things to do to actually minimize any liability for bad hiring decisions. So on the actual job description, one, you want to have a job description that clearly outlines, here are the job duties, here's the expectations. Having a disclaimer is really helpful. It could be as simple as job duties and expectations can and will change when needed. Employees must perform all duties with or without reasonable accommodation. This allows that employee to engage in an interactive process with you if they need some sort of accommodation due to their own needs. And so having some disclaimers on the actual job description is really critical. The other thing is to avoid using anything that would be considered illegal or an illegal policy. So if you were to have something on the job description that said this position is being hired for a schedule of 40 hours a week. If you work over 40 hours, you won't be paid unauthorized overtime. The intent of that policy, I understand, that is great. Unfortunately, and especially in California, but really anywhere, that would be challenged very quickly. And someone could point to that later in an unpaid wages claim and say, you have an illegal policy here. This person's claiming they weren't paid wages. You seem to have a practice of not paying people for the time that they worked. And now you're going to be penalized, or, here's fine, here's penalty, or now we have to go through this lawsuit. And then where required, including California, it's critical to also include a pay range. So what is the minimum and expected minimum and maximum of the range that is now required in California on all job postings if you have, I think it's 15 or more employees. So maybe more relevant for larger work sites, but just something to be mindful of, that most candidates are wanting to know what the pay is. I think that also just helps weed out people who are far outside of the range.
So Cheryl, I've got a question.
Sure.
A lot of the folks that are watching now are either attorneys or fiduciaries. I got a sneaking suspicion we have more fiduciaries than attorneys today. And just, for myself as a fiduciary, okay, like for instance, as the administrator of a pooled trust, I never actually go to the work site and that sort of thing. So when we're looking at these best practices, usually the hiring, I think, is initiated by the family. And we tend to be we end up hiring you, here, signing all that paperwork, and there is a respectable amount of paperwork to sign, so, and all of that. But in fact, we're mostly just paying the bills, right? Now, my understanding is he or she that pays he or she that pays the wages is probably in line to be the employer. So when we're getting down to best practices, because there's kind of a combined, we're kind of splitting the baby here, right? Because the typical situation is the family knows what the needs are and that kind of thing. But is it best the fiduciary be more involved in the hiring process, or?
I would say if the fiduciary is also the one who is like collecting all the new hire paperwork and paying the wages from the trust account and all of those things, the trust is going to be the default employing entity. And so that does directly tie to the fiduciary. I don't believe there is a need to be overly hands-on. I think it is in an ideal world, and I know there are lots of competing priorities and lots of time, in an ideal world, the families are armed with some of the tips and best practices. One, it's going to make their hiring more successful because they are usually the ones who are doing that, unless they've engaged a home health agency or that type of formal entity who's doing a lot of that placement for them, or a care manager, professional care manager. Sometimes those are services that they bring to the table as well. So there are resources out there for families, but in an ideal world, they could be maybe armed with some of these as maybe as a fiduciary, maybe as part of the services being provided. There's some, knowledge sharing of some sort with them on best practices.
I'll tell you, as an administrator of a pooled trust, since we basically deal in volume, we probably have a pretty good idea of what the market looks like. And I would tell you, housing is numero uno, but attendant care is a close second. That is a big part of the job, and all that.
Yep.
So anyway.
Yep. Good questions. So yes, and then I guess moving on to the actual interview, some important takeaways from a compliance or liability perspective. Again, sticking to the script, right? If you have questions outlined ahead of time, then you're less likely to wade into dangerous territory. You're more likely to wade into dangerous territory when you're not prepared and you're sort of sitting there winging it. And then you just start to go off in kind of like the gray area, I would say. So if you have questions, you stick to the script, then it's really difficult for someone to turn around and say that you weren't asking questions that were job related. That's really the point of this. Second thing is to avoid making any assumptions. If you were looking for Sunday shift coverage, then just be very clear about that. We are looking to hire someone to work on Sundays. Does this schedule work for you? A roundabout way that could lead to some hot water is to say, do you go to church? Are you religious, right? Asking those questions are, not job related. It doesn't matter if they go to church or if they're religious. What matters is whether or not they can work on a Sunday. And so not making an assumption about people who go to church or who are religious can never take a job on Sundays. That is where you want to stay on the side of is not making that assumption. Or, hey, we have a requirement. You need to be able to lift 40 pounds pretty regularly. Are you able to do that with or without accommodations, instead of how old are you, or making assumptions maybe about someone's build or age or anything and their ability to perform a physical task. And finally, in California, you actually can't ask folks like what they are making today at their current job, what they've made in the past, because of these same wage and wage transparency laws that are in effect. So the more appropriate thing to ask in the interview is to simply say, we're looking to hire someone and pay them X dollars, or a range of X to Y dollars. Does this work with your salary expectations? If they say no, then you can say, what would align with your expectations? And that's the way that you would want to navigate the salary or the pay question. And then finally at the offer stage, so you've gotten near the finish line, you want to make an offer to someone, I would recommend you always check references just to avoid negligent hiring. You want to get some professional references, ideally professional, ideally from past supervisors. Once the offer letter is extended or the written offer is extended, always run a background check. This is so critical. These are very, vulnerable positions, isolated positions in a lot of cases. It would be a pretty bad outcome to learn after the fact that someone shouldn't have been hired because of a criminal past. You never want to do this before the offer. You can't run background checks as part of your selection or narrowing down process. It has to be kind of a post-offer, could be pre-employment. You don't have to have them start yet, but you definitely want to make sure that offer has been extended and you get the right authorization to run a background check. And then just finally, and this could get nestled in with the background check or references, is just to make sure if they say they have a certain license or a certain level of experience or education that you really need in that role, that's being verified somewhere along the way. So those again are the tips, the best practices, and the compliance reminders to ensure good hiring practices at the start of the employment relationship. Now moving along into just managing the day-to-day and everything that goes into it. We'll spend some time. Again, we're going to shift gears a little bit. You've found the perfect candidate. The family's really excited. Hard part's over because we all know how hard hiring really is. And I would maybe argue that a little bit, that the hard part is not quite fully over. The focus shifts. Now it's about making sure that employee is performing successfully in the role. They're content in the role. They're kind of getting what they need. Again, this is going to help ensure that ultimately your client has what they need in terms of continuity of care, and getting some quality services that they need. So we'll double click on each of these areas. There's probably dozens that I could have put up here, but these 5 really set, I think, a good foundation for being able to proactively manage the day-to-day and all of the things that really come into it. Managing workers it requires time, it requires patience, it requires flexibility. Sometimes this may fall a little bit more on your plate as a fiduciary. Sometimes it's simply just with the clients, but you're kind of hearing about it on the back end. You're getting the earfuls when they're frustrated with the employees or something going on at the workplace. So let's dive in. We're going to start with communication. Communication is important early. It's also important throughout the entire work arrangement. So initially, it's going to help set the tone for your client to establish their credibility as the manager, as the employer. So having a sit down early on with whoever is going to be in that seat, whether it's the beneficiary, whether it's someone in the family, whoever is really managing the day-to-day, to have that just initial, glad you're here, here's how things work here, here's what's expected, what questions do you have, and getting that rapport set up from the get-go will help things down the road. Ongoing, you want to keep that rapport. You want to always have that opportunity to create what I would call a continuous feedback loop. So you want to destigmatize having to give people feedback. And the best way to do that is to have constant touch points. And a lot of this is really falling, I know, on the families to do. So again, this might create an opportunity where some of these best practices could be shared with them. But you want to destigmatize feedback, because sometimes people hear feedback and they kind of tense up and they don't want to go to work anymore and they're not feeling so great. But understanding that that's just coaching and communication and making sure everyone's staying on the same page. If that trust can be established from the get-go, it's going to really help the relationship overall. We get a lot of questions from clients about what is required for annual performance reviews, or how would we go about doing those. I will say from a legal standpoint, there is no like specific cadence that is required. Anyone who is working for money, they want to know how they're doing generally. Most folks, I would say, fall in that bucket. So it doesn't have to be a formal process where there's 20 boxes on a page and you're rating people. But you could really simplify it and just say, hey, here's what's working really well. Here's what can be improved. Do you have feedback for me? Is there something that could make your job easier here? And then get things kind of documented and memorialized. So it can be really watered down, pretty informal, but it's still important to have those touch points. In terms of recommended timing, I would say starting out, it's maybe a little more frequent. So maybe after the first couple of weeks, a quick check-in. How are things going? Here's my observations. Maybe after a month or two, and then you can kind of shift to maybe once a year, having a little bit more of an intentional sit down just to check in and see how folks are doing and give feedback. This is going to set the stage well, because there are going to be times that issues do surface. And if you have this foundation built, then you can kind of you can then build on from that to address the issues that are coming up. Before we get into those issues, though, the other kind of upfront piece to note is to have just clear policies. Sometimes this could be a care plan that outlines like, this is what needs to be done in this order for the day, and that's something that the family or maybe a care manager has put together and maintained. That is great. That's a good starting block. Anything else that you want to set in terms of ground rules: keep your phone on silent. Don't be late to work, you show up on time. Anything that can set ground rules you want to have, that's going to show up as being a very and especially when you have multiple workers, right? So a more robust is never needed. You do not need to have an 80-page manual for it to be effective. You just have to have it be clear and easy to understand and consistently applied. So if you have maybe 4 workers coming in and out of the home, you have a workforce. That's managing a workforce, and you want to have some just basic shared ground rules that everyone is looking at and pointing to. The caution here is similar to what I shared on the job description. You want to make sure that none of the policies are worded poorly, or that can be that include some sort of illegal language. So again, with that overtime example, if you have an overtime policy in a handbook, let's say, and it says, we will not pay if you work unauthorized overtime, that would be, again, that's an illegal policy. It's actually better to have no policy in that case than have a poorly worded policy. It's better to say an employee who works unauthorized overtime may face disciplinary action up to and including termination of employment, or something like that. So you can't punish an employee by withholding pay. You still owe them the wages, but it doesn't mean you can't follow a different disciplinary action or give them a warning and another warning. And eventually it may lead to a bigger conversation down the road. If you do have policies written, it's good to review those about once a year. Make sure that nothing substantial has changed in the employment law landscape that needs to be factored in. And as I mentioned a few minutes ago, it's inevitable that issues are going to come up, right? So these are lots of people working, and people are people, and things come up in people's lives that need to be addressed, or maybe performance isn't going so well. So something can go wrong on the employee's end. Maybe they get injured. Maybe they need some time off because they're having a baby, or they need to care for a sick parent. Maybe they're not getting along with another coworker. So there could be an issue that's surfacing at the employee level. There could be an issue that's surfacing on behalf of the client. The employee isn't meeting performance expectations, or they have attendance or tardiness issues. Maybe there's an employee who's just demonstrating a really poor attitude, or they're creating a bit of a toxic work environment for other folks. No matter what comes up or when, there are a few things to keep in mind. One is issues are not going to go away or resolve on their own. So being timely when looking into those issues is really important. You really want to try to get things resolved before they snowball and become a bigger issue. Second best practice is to be discreet. So whoever is charged, I would say, with having to look into the issue or resolve the issue with the employee, the last thing that you want to do is share that information with other workers or somehow contribute to the gossip train. That's going to undermine the credibility of that person as as the manager or the supervisor, and could lead to just, again, more snowballed issues. And the third takeaway is really that there are some really technical issues that could come up. If somebody comes and says, I have a medical condition and I require an accommodation in my job, this is a very technical area of HR. This might be an example of knowing when to sort of flag something that feels really technical and legal and get some support, whether it's from a trained HR professional, from an employment attorney. Examples of more serious things are things like work comp injuries, leaves of absence, accommodations, harassment claims, hostile work environment claims. Going it alone may not make sense. And so kind of keeping an ear out for those, I'll call them red flag situations, is also a really critical part of managing the day-to-day. Great. So that is what I'll talk about on the dealing with issues topic. Moving on, we have two more in this section. One is to maintain good records. So as the employer, time cards is obvious, right? So if you're paying folks, you want to maintain time cards for a period of years. I believe in California, it's 4 years. But it is legally required to maintain time cards and payroll records for all hourly and non-exempt employees. It's not only the law, but it's also going to be your best defense against a claim. If you have the time card records, if you're collecting time cards from employees, then if that employee comes and files an unpaid wages claim, it's not a slam dunk, but it's certainly going to be a lot better and in your favor to be able to produce time cards that employee completed all along the way, versus not having anything to share, and then that employee showing up with the journal that they've kept all their hours in over the past few years. So in those situations, it's expected that you would see an audit back several weeks, several months, even a few years, just to fight unpaid wages claims. So having a good system for maintaining those records is really important, and knowing when to destroy those records is equally important. You don't want to keep things longer than you need to keep, because that could also open you up and make everything sort of discoverable instead of just the part that's really within the view of that particular claim. In addition to time cards, there's other records that are important to keep and retain according to the state or federal laws. So a few of these are any hiring records, I-9 forms that help establish that employees eligibility to work in the United States, other tax records, things of that nature. And finally, I just want to end on paying compliantly. I know I spent some time in the beginning of this presentation saying that, payroll is important, but it's not the most important thing. There's a lot of other things that you have to manage as an employer. But I want to stress that it's not because payroll is not a critical piece. On the contrary, it is the most tangible thing that you're going to produce for employees on an ongoing basis. Most folks don't want their pay messed with. They want to know that they're going to get paid, and paid accurately, and paid timely. This is also an area that I feel very comfortable speaking in absolutes. So one is, calculate the time correctly. Make sure that time card is completed fully, and that you are really calculating all the regular hours, all the overtime hours accurately. Adhere to the various minimum wage laws that are circulating out there. In California, it's not just state minimum wage, but there are county level minimum wages. There are city level minimum wages. LA County is particularly tricky because they have an LA City minimum wage and LA County minimum wage. and all sorts of overlap in between on whether the city is an incorporated or unincorporated city within the county, and whether that means they get the county or the state minimum wage. So you need a little bit of a decision tree for some of the areas in California. Paying overtime correctly. In California, there is daily overtime in addition to weekly overtime. There is special overtime for live-in employees versus non-live-in employees. Generally, overtime is required after 40 hours a week, but in California, it's after 8. There's double time after 12 hours. There's other states out there that have other nuances like 7th day overtime rules, holiday overtime rules. So being mindful of the rules in the area that and this is all based on where the work site is. So usually where the family residence is, that is the laws that are going to be in effect at the time. If you have employees who are living in or are working extended shifts and you are in California, just know that sleep time deductions are not allowable in the state of California. Outside of California, if you have clients outside of California, you can apply a sleep time deduction so long as certain conditions are met. So that would be the shift is a 24-hour or longer shift. The worker has adequate sleeping quarters away from their work area, and that individual can get a minimum of 5 hours of uninterrupted sleep. And if you have those conditions and you've memorialized something in writing, then that employee can legally be deducted between 5 and 8 hours for the sleep time deduction per 24-hour shift. And the last watch out when it comes to pay is for travel time. So we get a lot of questions about how does compensation work when there's overnight travel and I need to take an employee with me out of state or maybe within the state, but they're going on some overnight travel. The time spent traveling is typically going to be compensable if it's falling outside of their normal shift hours. All of the costs need to be covered. So the lodging, the meals, any of those types of incidentals. It is recommended to have, it doesn't have to be lengthy, but having some sort of written travel agreement with that individual. Maybe there are set hours that they're going to be working. Maybe they're going to have some designated time off within that period of travel to do their own thing. If they want to go sightsee, if they want to, go out to dinner on their own. If that is scheduled off time, they can clock out as usual, but it's good to just get on the same page so there's no surprises at the end. The other thing that typically sneaks up on people is what are the room sharing or the lodging arrangements. If the worker is actually in the room with the client, so let's say it's a nanny situation and the nanny is going to share a room with the child that they care for. If they're sharing a room overnight, then that is all compensable time, even if everybody's sleeping. So it might have, and that's okay if that is the lower cost option, but usually it makes more sense just to get a separate room for that person so that they could kind of retire and be off the clock for that overnight time. So knowing some of these pay parameters really helps with budgeting for travel and avoiding what I would call like surprise or balloon costs at the end. Okay, so with that brings us to our fifth and final tip, which is now at the end of the employment life cycle and focused on the terminations, and especially when we're talking about involuntary terminations. We've unfortunately seen involuntary terminations go wrong. And so wanted to, with that, just share our final story as we kind of kick off this section. So we had this was a few years ago now, but we had a client and they called us because they had released one of their employees. And we said, oh no, what happened? And what they shared was that employee had been working with the client for about 11 or 12 months. So just about a year, had continual attendance issues pretty much since day one. This was creating a lot of coverage issues with the client, but also with some of the other workers who had to step in last minute and cover shifts. So it was creating a lot of issues across the team. And, based on our conversation with the client, it seemed pretty straightforward. We learned though that, it really wasn't documented anywhere, but it had been done. There wasn't much we could do at that point. Felt fairly straightforward until we received a notification that this employee had filed a claim with the EEOC, the Equal Employment Opportunity Commission, and with a demand letter from the attorney for $300,000. And so the real story behind what was shared at the time is this: the employee was actually needing to take some time off during the last trimester of her pregnancy. It was a high-risk pregnancy. She had been making comments about not returning to work. Everything about her attendance issues was absolutely or was validated just by other folks, and it seemed like that really was happening. She had a ton of attendance issues. So the client, ultimately looked at the situation and said, you're not going to return. You're going to have this baby within a few weeks. You're not going to return. You've had these attendance issues. We're all sort of at wit's end. Just don't bother coming back, right? And of course, she immediately contacted an attorney who, picked up the claim as frankly they should have. And her claim was that she had been discriminated against because she was pregnant. Now, this was not the case, but the optics of this were not favorable. And through negotiation, we were able to settle this claim for $100,000. But this was a really painful settlement. It's part of why a team exists, but doesn't make it less painful. But this settlement was also made to someone who was otherwise not a great performer. So someone who had continued attendance issues, hadn't been with a client for even a full year yet. And the settlement value was really the equivalent of about 3 years worth of pay based on what she had been working in that first, several months or year. So how to avoid this? What should have happened? One, the attendance issue should have been addressed immediately from the get-go, from the start. It should not have gone on nearly as long as it did. Those issues should have been documented when they were not resolving. And ultimately, even with those performance issues and even with clean documentation of those performance issue, because of the other circumstances, because this is an employee who is in her 8th month of pregnancy, the optics are so critical in these situations, really should have brought in good legal counsel to help navigate the way forward. There are always options. This employee could have been placed on a leave of absence early, could have negotiated some sort of potential severance to part more amicably. The employee didn't want to work there, even if the job was held back open. And so really there could have been some other avenues that could have been explored in that situation, had things been handled differently from the get-go. And that really, I think if I had to say, what are the 5 things to do to ensure, as safe a termination as possible? There's no such thing as a risk-free termination ever. Anytime you take any sort of adverse action against an individual, there is some risk that is born in that type of action. But the first, again, is document the issues. 2 is not waiting. You never know what's going to happen that could make something more difficult or not possible in the future, and really just delays things. The third is to plan ahead. These conversations are not easy. A lot of times, and we see this with a lot of clients, it's especially hard in the type of home environment that, we work right alongside. Something feels very personal about the job, about these types of roles that folks fulfill. And there's a lot of family dynamics oftentimes. And it's not as easy as most corporate positions where you're sitting in this conference room and then everyone kind of, you're sitting in a living room or a kitchen, and there's something about it that makes it a lot more personal, in addition to it already being a really tough conversation. So planning ahead for having a difficult conversation is important, really knowing your talking points. And also planning for other critical logistics. In California, if you are terminating a worker and it's an involuntary, you owe them their final paycheck then at the time of the termination on their separation date. So knowing that ahead of time allows you to be prepared and avoid any sort of late payment or failure to pay timely final wage payments claims. And protecting, and it also allows you to make sure you're putting the right safeguards in place to protect your client's interests. So are there locks that need to be changed? Are there passwords that need to be updated? Do others in the community need to know that, hey, this individual is no longer an authorized contact here? It's important to safeguard your clients, their valuables, and make sure that everything is as smooth as possible. The fourth tip is to be professional, but to also be empathetic. Don't underestimate the human element here in the situation. Being let go is an incredibly difficult, and for most people, it's an incredibly difficult thing to go through. And, you know, we have heard situations of employees being let go by a Post-it note left on a window, very impersonal, doesn't allow that person some dignity in the process. And believe it or not, just having closure and being able to retain some dignity in something like being let go or fired is sometimes the thing that is the difference maker between pursuing a claim and moving on. And a lot of times people just want closure so they can move on. But if they don't feel heard or respected, they are more likely to go potentially down a different path. And the final reminder is just, again, context matters. If you have that red flag situation or high risk situation, someone's, you know, just coming off the heels of reporting a workplace injury or a different type of violation, or they've complained about maybe you've, you know, made a mistake on their wages and then now you want to fire them. Like any of that stuff would be considered a higher risk situation. And again, engage an attorney or a trusted HR professional to help navigate that from a more technical standpoint. So those are the, you know, kind of 5 tips, but just, I want to leave a final bonus tip, really. This is tip 6, which is to know your options. Again, doing this stuff really well, it requires a lot of time. It requires a lot of expertise. And even if you are the world's best and most responsible employer, there is still a lot of liability for yourself, for your clients, for the families. And things can go really well for a very long time, and then they don't. And it just takes a single incident to create kind of a disgruntled employee or an unhappy employee who might file a claim or a lawsuit. And cutting corners with any of this is never going to be recommended in any scenario. And so knowing kind of when, okay, I feel like I can go it alone here versus I need to leverage a skilled professional in this situation is a really important decision point. And there are a lot of different options to assist depending on what is important to you as the fiduciary, what's important to your clients, and what's going to get their needs met ultimately. This is an eye chart, so I will not go through every bullet here. I know there's a lot on the screen, but the most important thing to be mindful of is what are you gaining, and then what will still be required of, I'll say you, but really whoever is sitting in that employer seat. So for example, if you are utilizing a home health agency or an employer of record service, the liability protection is there. But in the case of, let's say, an employer of record service, like team, for instance, the family, the beneficiary, someone else is handling the recruiting, managing the day-to-day. So you need to make sure there are folks who can fulfill that role in order to take advantage of that type of option. If you're using a payroll company or a CPA, surely there is a huge lift when it comes to the payroll and payroll tax side. That burden will be lifted. But at that point, the trust is likely the one who's named on the W-2. And so the trust is the employing entity in that situation, which means that from an employer responsibility, that typically is going to fall on whoever is sitting in as trustee. The only column I will advise against is the cash column, right? So again, paying under the table is probably going to be the riskiest of all the options, and most likely to kind of snowball into a bigger issue. So different clients are going to need different things. Knowing the trade-off, knowing, what are the budget constraints here? How much of a kind of a flexible solution are you looking for? All of that will help you determine which type of option maybe fits the best. All right, so we've covered a ton. Just a quick recap. One is being an employer carries inherent risk, even when everything is done really, really well. It's there, it exists. Two is if wages are being paid from a trust, the trust is the de facto employer. Third is managing employment relationships. Take time, take some expertise, and it's really important to manage these well from start to finish. And I'm hoping that some of the tips that were shared today will assist you and clients in that endeavor. And then finally, again, know your options. Know when you need to leverage resources, contact an employment attorney, contact an HR professional when you are faced with kind of a red flag situation. And Steve, we have our third code.
Well, a couple things real quick. Cheryl, we got to go back. They're not that fast, Cheryl.
I wasn't even touching it that time.
First off, let's get this out of the way. Our last code for number 3 is 7043. That's 7043. And once again, you need to enter that into the MCLE form, which you can find at gspt.org/attorney resources. Now, if you signed in a little bit early or a little bit late, no, we're not going to send you the codes, but this is going to be up on our YouTube channel here. I'll bet you by tomorrow here. So that's going to be how it works. Also, Cheryl, I will agree with something you said. You packed a lot in 1 hour and 14 minutes here. So we have 16 minutes to go to get our hour and a half and all that. So I do have some questions. Can we go back one slide?
Yes.
Okay. I mean, I just want to emphasize something really quick, just as an attorney, and I've gone through this, and I know this can be difficult because a lot of the families, when they get these settlements, it's never enough, right? And I know they're just trying to do the best they can to get the assistance they need. But, one thing here that just jumps out for me is I think you can pretty much assume that if wages are paid from a trust, the trust is in one form or another going to be considered an employer. I mean, that's going to, and I'll lead to a question. So here with this, which is, oftentimes, we as fiduciaries here, most of the hiring is going to be done either from the family, or we have a lot of beneficiaries that are totally competent and they do the hiring themselves. So obviously hiring an attendant is a very personal thing here. And I know oftentimes we'll be told, well, I'll be responsible for this. You just pay the bill. And that's going to make everything okay, right, Cheryl?
You're asking whether...
Like I can have one of my beneficiaries or families hire somebody and then go ahead and tell me that I'll be responsible if anything goes wrong. I just want you to pay the bill.
So that would probably not be enough, because those bills need to be paid. Someone's name needs to be on the pay stub and, on the W-2, there's going to be something there that's either referencing an individual's name, a trust name. So I would say likely not.
Yeah. And I know sometimes the tension we have, because, this is, once again, the job of the attorney and the job of the fiduciary oftentimes, is often just to make sure that everything is compliant. And oftentimes, our job is to tell people that things they don't want to hear. But, I would say that in a lot of cases, one thing before you take on the case here is to find out if there's a big issue as far as payroll and that kind of thing. Because once you take this task on, it basically, it's your wheelhouse. And I know sometimes it can be very unpleasant when the beneficiary of the family has one idea of the way this should go, but hey, we're kind of stuck following the law here.
Yeah, it's definitely complicated, and usually there's not a black and white answer either, because at the end of the day, these are just it's such a nuanced set of circumstances. Again, we're not talking about, hiring for McDonald's where you have like a big company and you have this, these policies. Like, this is an individual client. This is a household. And you want to have enough flexibility to be able to honor the things that are important to them, because that is really who is at the center of all of this. And there are some, tough, there are some markers of like, okay, can't cross this line, but maybe you can be a little more flexible here. And that's why, navigating these requires a level, I think, of just nuance and sophistication sometimes. And you may not be totally happy with the outcome, but you get to an outcome that you can kind of live with, right? So we've had situations, for instance, where maybe it's the world's worst employee in the world, and the client's like, okay, I'm glad they're gone. I don't want them to get a dime from unemployment because they were a terrible worker. It's at the end of the day, you, as an employer, you have to kind of pick your battles and say, I understand that. And, I acknowledge that. And you understand the intent behind what they're saying. But at the end of the day, if that employee doesn't get unemployment and their stream of all income is cut off, now they're going to feel more in a situation to say, well, wait a second, I need money. I need to survive. I may have a claim here, so you have to constantly choose your battles. It's really when you get enough kind of battle wounds under your belt, when you've been in the industry long enough, then you learn the rhythms a little bit more, but it is a complicated thing. And I think it's important just to try to talk through several options and see which one can most people kind of live with at the end of the day.
Okay, so we do have a couple of questions here. One
Sure.
is, would the consequences of paying a respite worker from non-trust assets still be the same?
I guess, where is that worker being paid from?
Well, let me take a stab at this. Let's say I'm the trustee of Junior's Trust, and the person who posted this, if I'm off base, let me know. But let's say mom says, well, I'll just pay her off the books for some respite. Is that okay? So I'm aware it's going on, but I'm not paying it.
There would be some risk there because the payments are being made off the books. So you're not withholding taxes. If you're still the same entity, in other words, like, what if during those hours that employee is then injured? Then they're not being paid for the hours that they're employed by the entity. So then who would be liable for that injury? So you need to have the payroll records kind of jive with what's really happening. So it does it happen? Am I aware of it happening out in the world? Yes, of course. But there is a consideration there. Could be risky.
And that may be a Noodleman level question. I don't know, who would probably, once again, so the question would be like, I'm aware of it, but I'm not paying the bill, right? And there's a fuzziness there, isn't there?
Yes.
Yeah. Here's another one. What if I hire a caregiver one day a week for 5 hours on a regular basis? Here, does that make me an employer? I guess
Oh,
in a way, is there a freebie? Like, what if you're hiring somebody for
can they say no? I guess so I know there are some carve outs, and we don't deal with like casual babysitters, let's say. That's like, not something we're quite involved with, but there are some carve outs for things like casual babysitters. But again, I think it's like, what does the expectation there? Is it expected that that caregiver shows up every Monday, works those 5 hours, clocks in, clocks out, and if they don't show up, they're going to get fired at some point? Or is it like, hey, we need help, but we're pretty flexible. Can you give us a few hours on Wednesday or Friday or whatever? There might be, there could be, but if it is like, this is your shift 1 day a week or 7 days a week, again, who is exerting, if you are exerting control over that person's schedule, and therefore livelihood, then there's an argument for an employment relationship there. Does that answer that?
works for me? Real common with the community that we work with is in-home support services, which I have rarely seen the amount of time allotted for in-home support services to be adequate. Any tips,
Yes.
like, if we've got, I know it's very common that we might allocate so much time to to worker A, right, of the IHSS, but then we're going to also pay them privately on the side. So some of the things, as far as when you're trying to coordinate between in-home support services for the same employee and paying wages through RMS or some lesser group here or whatever here. Any tips? Like, one is, we had a parent who literally slept at the foot of her child's bed, literally, and this is not uncommon, right? So we can tell somebody that you can't work over 8 hours, but that's not going to work for her. She is going to sleep at the foot of her child's bed. So coordination between IHSS and paying privately, like,
Yep.
what if you go over 40 hours? Do we have to pay the same amount as IHSS? Can we pay them more?
Yes. So I can only speak from Team's perspective here. Team is a separate entity from IHSS. We want to make sure that we're not paying for the same hour that's being reported to IHSS. That would be a no for us. Yep. So as long as what we have seen is IHSS hours maybe go first, and then anything remaining is kind of more considered private pay, and those are the hours that get reported to Team. Our employment terms are separate, and IHSS doesn't really have, like, there isn't really a bearing on that piece of it. So we could pay them the same, we could pay them more, we could pay them less, as long as it's minimum wage. It's just, it's a different entity in employment terms here. I think with other programs, if there is a family who is the employer and they are the employing entity for a different type of program, I've heard, like regional center hours and other things, like, but if the family is the employer and the family is also the employer for other private hours, that's where there can be some potential need to count all the hours for overtime purposes.
Okay, and I'm pretty certain I know the answer,
one employer.
but here's something comes up. The rate of pay for IHSS is disgusting, right? I mean, it's just, part of it is what it amazes me sometimes anybody would show up, and oftentimes they don't. Okay. And if you go, well, okay, let's say the wage in that county is $16 an hour, but really it should be something like 25. So can we just pay the difference here for the IHSS hours? Like if somebody's hired for 30 hours a week and their rate is $18, can we just kick in an extra $7 or $8?
So there is one. So again, because talking a little bit from team's perspective again, like if this were presented to team, again, we don't want to touch the IHS. We're not touching the IHSS hours. So it's a separate entity, separate deal, separate rate, whatever. For team, maybe there's hours, maybe there's not hours, but there is nothing that prevents us from hiring, agreeing to employ a worker that the family's found to be on call for that client. And in that arrangement, we can say, in exchange for being on call, we'll pay you $200 a week or whatever, X amount of dollars per week. You agree to be on call. If you do work team hours, here's your time card. You'll get paid X dollars per hour for each of those hours on top of that on-call payment amount. And so there is, it's hard to speak kind of in two generalities, but there is something that we have found ways when we've taken a look at those situations to carve out a specific arrangement with team for some level of compensation.
So the way we've operated on this is, so far it's worked, unless you tell me it doesn't, and then I'm going to erase this question here. But what we've done and what we've been told is, like, if somebody's allocated 100 hours of IHSS, what you pay for the 101st hour is your business, and you can kind of play makeup there in those cases, because, you know, obviously not only having good workers, but workers you can rely on is kind of important.
Yeah. It's absolutely really important. Yeah.
Okay, then I will not erase this question. I want to make another pitch, and I know I'm working with Joe out of your office on this, so we'll be doing a program on this, and it's called The Invisible Mother. But why don't we touch on, just for a moment, the parent or the family caregiver? And I just want to make this pitch out there. I realize that we're always trying to do an almost impossible job of providing, you know, community assistance here, and try to do it in an economical way. And when you're talking about caregiving, that's not cheap. I do want to make this pitch out here about paying family caregivers. And I want to tell you, I learned this from a parent where one of my first clients, and let's face it, I had no idea what I was doing when I first started practicing. I just started making stuff up, and over time, you know, I got into it. But I had a parent who absolutely refused any payment from the trust. There was plenty of money from the trust. And then eventually the child did remarkably well and left home. And there's the parent who had the beginning of a back injury, who had no work history. She had no FICA, no nothing. In fact, her comment to me is that she had tried to apply for a rental, and she had no credit history, and she was simply invisible.
I'm so glad you brought that up.
Here is not only this, but the other part of that is, let's get back to this. I'm a former nurse who used to work with these folks, and I am a rarity because I can stand up. You know, I can pull an anchor up. Most of the folks I know who did this for 20 years, they cannot, because of, you know, the injury just comes with it. So any comments on the family worker?
Yeah. I'm really glad you brought that up. Actually, it is true. Like paying people on the books is not just about avoiding the IRS from knocking on your door or getting into tons of trouble or lawsuits, but like it legitimizes the profession, which is really important to this industry, I believe. And a lot of family members do overlook their future needs as well. Like, if you're not paying into Social Security, you know, say what you will about whether that's going to be around for all of us, but it's definitely not if you're not paying into it. And if you don't have an unemployment account to go file for unemployment benefits, that's a bad thing. And then not having any credible employment history. You can't get a loan. You can't buy, you know, it really limits some of the things that are necessary in in life. And so I think people overlook that and they think about, oh, I don't want to, I don't want any expenses to come from the trust, or I don't want this, or I don't want that. And sometimes it's from a noble, very noble place. But it does do a bit of a disservice to especially family caregivers.
I'm an absolute believer in this and all that. And this is something I really, both as an attorney and as a fiduciary, I try to counsel the families that, yes, I know you're trying to squeeze every last penny and that kind of thing, but you're an important resource here, and there is a risk. I will tell you another good person to have on the team and is a care manager. We got not that long ago the most lovely picture of a Hoyer lift we had bought 3 years ago, still in the packaging, right? And by the way, merely buying the Hoyer lift doesn't really do much other than give you a nice place to hang your jackets and clothes. And by the way, they're great for hanging clothes, but they're also good for preventing injuries. And I know for myself, I had a very vicious charge nurse who said she didn't want to fill out the paperwork, and she said, damn it, you're going to learn how to use this Hoyer lift and all that. And I probably owe her a big thank you, because believe me, it's a lot easier not to use it, but it's a really stupid thing not to use these things. So
yeah.
Cheryl, we have come to the end of our time here, and all that. Any last thoughts here? And if somebody is looking at reaching out to team, how might they do that?
Yeah, you are welcome to reach out to me directly. If anyone on the call just has follow-up questions or would just like more information on team services, happy to take a call or an email there. Steve, thank you so much for allowing me the opportunity to speak today and for including me in this series. Really appreciate it.
Cheryl, thank you, and the folks at team for all your assistance and all that. So I want to thank everybody for attending. Hopefully the video will be out tomorrow for it. Please stay tuned. We have new programs coming up constantly. And with that, I want to thank you and happy advocating.
Thanks, everyone.
And that's a cut. Okay.